My lord, seeking review of the order passed in writ petition. My lord, may kindly appreciate the record of the writ petition. My case was that we are the leaseholders given by the pujari of a temple, and we are there in the possession for 30 to 40 years.
Lease given by Pujari.
My lord, though
I'm just trying to understand the thing. I'm not repeating the thing.
Yes, my lord.
Instead of mesmerizing, I just spoke it out.
Yes, my lord.
So the lease was given by Pujari.
Yes, my lord. Lease.
Now you have understood the question.
In light of Khandera 1992, I know my lord. So lease was given by the pujari. We were there in possession for 30 to 40 years, and we are living. And the land was in respect of the Choti Shala temple, which is a pagoda. We were being given the notice by the Tehsildar Nazul. So my case in the writ petition was the Tehsildar Nazul have no authority to evict us because that notice was without jurisdiction because the land was of the Marquis of Kop and the Nazul has no jurisdiction of the Marquis of Kop land. This was my case in the writ petition. State contested it with the stating that the controversy involved is parameteria with the direction issued one in the PIL, and thus it requires to be disposed. On the date of hearing, my lord, it was disposed of in that PIL, though, my lords, for some reason, I could not be there while the hearing. So, my lords, by the statement of the state respondent, it was being disposed of. My review is only on the ground that whatever the merits may be, but my petition was not in consonance and in parity with the directions of the PIL, and it could not have been disposed of in light of the PIL.
What is there to show that you were granted lease by the Pujari?
All are annexes.
देखा ये so WP का record दीजिए.
Yes. Starting from page 46, my lords.
Your lease is
ये पेज 46 एनेक्शर P2 कलेक्टिव है, पट्टा है ये, मंदिर श्री राम जानकी सोनसो.
this is 46. अच्छा.
Yes, my lords.
ये है पट्टा.
Yes, my lords.
Oh.
It was
ये
given.
सब पट्टे हमने बहुत सारे देखे सेकंड अपील्स पे. आइडेंटिकल.
फॉर्मेट
यही फॉर्मेट.
वो फॉर्म उस समय यही होता है.
अरे भाई साहब वो तो ठीक है, किसी केस में 100 साल पुराना पट्टा भी यही फॉर्मेट, किसी में 40 साल पुराना पट्टा यही फॉर्मेट. ये क्या मार्केट में बिक रहे हैं? और सेकंड अपील दे धड़ाधड़ इसी के ऊपर.
वो तभी वो माय लॉर्ड का व्यू सही है कि देयर शुड बी अ सपोर्टिंग ऑर्डर आल्सो.
नहीं, अपार्ट फ्रॉम दैट सेकंड अपील्स आएंगे. Sir, I'm not making a general.
I know. I'm getting that point.
I'm not making a general observation.
I'm getting that.
So it is confined to that case because judgment has already been pronounced. Therefore, I can share with you.
My lords.
Ex zamindar had granted me a patta.
Yes.
Whether that person was a zamindar or no, nobody knows. Whether it was a zamindari land, nobody knows.
How his name was recorded, nobody knows.
Nobody knows.
Then, from when he was zamindar, nobody knows. Till what time of possession, nobody knows. And what he was doing there at that relevant time, nobody knows.
Now, suppose if patta was granted by zamindar, then at least it must prior to 75 years.
2050 plus 20 years.
Yes.
यही करने से लगा हुआ था. Format is
form जो होगा मतलब उस समय.
So that was for the last 100 years. Same format is going on.
छपा रहता था हमारे उससे.
Same format is going on. Secondly, profound पुजारी is contacted.
जब हम स्कूल में पढ़ते थे तो मेडिकल लीव का एक फॉर्म कलेक्ट्रेट में मिलता था. वो कलेक्ट्रेट का जो लीव फॉर्म होता था वो डॉक्टर साहब से साइन करा के स्कूल में देना पड़ता था. और वो जहाँ फॉर्म मिलता था वहीं बगल में क्लिनिक भी थी. तो सबके फॉर्म.
मिस्टर सर, मैं यहाँ से बैठ के कुछ जनरल स्टेटमेंट करना. मैंने जो आपको एग्जांपल दिया because I had decided, therefore I shared my view. So whether it is a general practice or it is an individual case, that is dependent. What I wanted to say is that in that case it was claimed that captain was granted as zamindar.
Yes.
zamindar मतलब 1950 में 2007 संवत से आप लोग वो कह रहे थे कि मैं
वो बेनिफिट लेते हैं.
मतलब 75 साल तो आपके इंडिपेंडेंस 50 से हो गए. उससे पहले भी 15-20 साल पहले जमींदार में दे दिए. वही कागज उस समय भी चल रहा था, वही कागज अभी 30 साल पहले भी चल रहा है.
वो फॉर्म एक
आज भी डबल पाइप.
मेरा सबमिशन ये है कि जिस लाइट में डिस्पोज ऑफ हुई है और डायरेक्शंस ऑफ द पीआईएल वर नॉट कवर्ड ऑन. whatsoever the merits of my case was.
नहीं, अगर कोई सब्सटेंस है तब तो
वैल्यू सब्सटेंस है उसमें जो
अब
स्लाइड में वो
substance-
डिस्पोज ऑफ हुई, that was
आपका राइट क्या है? नंबर वन पुजारी, he has no right. Settled law है कि that he is a servant of the deity.
I was challenging the process
I'm not
of
saying-
my eviction.
I'm not saying. Your induction is itself is illegal. Number one, माफी औकाफ प्रॉपर्टी है,
हाँ.
स्टेट गवर्नमेंट की है, राइट? अब तहसीलदार ने दिया है, अब तहसीलदार नजूल डिपार्टमेंट का है, इसलिए नजूल डिपार्टमेंट नहीं दे सकता है।
That was my jurisdiction.
तो है तो तहसील तो गवर्नमेंट
In light of Kanchaniya, मान लो तहसीलदार can give me.
Hmm?
In light of Kanchaniya, तहसीलदार can evict me under 248. But only my jurisdiction was that this particular tehsildar was not having jurisdiction. This was my petition.
RP 554 Gaurav Mishra, Shri Excellence. This review petition under order 47/1 CPC has been filed for recall of order dated 24/2016 passed by coordinate bench of this court in WP number 4947 of 2010. The honorable judge who has passed the order under review has debited his office. Therefore, this review petition has been listed before this court. Next, it is submitted by counsel for petitioner that the case of the petitioner was not covered by the judgment passed by the PI, judgment passed in PI, and therefore the dismissal of the petition in the light of
It was disposed of in light
the
of
disposal of this petition in the light of judgment passed by division bench of this court in the case of Rajkumar Mishra and another versus state of MP and others decided on 25/10/2010 and WP number 1331/2009 bracket में PIL is an error apparent on face of record. Consider the submissions made by counsel for the applicant. It is the case of the applicant that applicant was inducted as a tenant by the pujari of the deity. Applicants were inducted as a tenant,
simply withdrawing it.
were granted lease by the pujari of the deity.
I'm simply withdrawing it with liberty to pursue the.
ना
Direction.
लिबर्टी नहीं दे रहा मैं
वो डायरेक्शंस तो है ना, वो उसमें लिबर्टी है कमिश्नर साहब को अप्रोच करने की डायरेक्शन.
मैं कोई लिबर्टी नहीं दूंगा, मैं सिंपल विड्रॉवल दे दूंगा.
Simple.
At this at this stage it is submitted by counsel for
To
applicant.
pursue the directions given by the.
ना मैं कुछ नहीं बोल रहा by the applicants that they may be permitted.
It was section 5 की तो.
It is accordingly dismissed.
धारा 5 की थी.
अच्छा. Since the review petition itself is being withdrawn, therefore कहाँ धारा 5 है क्या?
सर आइए 319 दिन का डिले.
2145/18 है बताया आइए ना.
2145/18.
ऐसा करना पहले ये 2145/2018 for the reasons mentioned in the application the same may be announced. Delay in filing this review petition is hereby condoned. फिर वो जहाँ को ऑर्डर आ गया था वहीं पे आके डॉट करके this is the concern for applicants seek permission of this court to withdraw this.
Name of my CGM. Number 21.
जी सर.
Not 5 year 2 month delay.
5 years 2 months. कुछ है क्या आपके लिए?
मेरिट पे लौट गया था. The respondent filed a suit for declaration and on the basis of adverse petition, the right of the respondent cannot be dealt. For the adverse petition, there are no date.
नहीं, but that would amount to reopening the case on merits.
That is.
691/2018. However, ID number 2132/2018 and application for condonation of delay of 5 years and 2 months in filing this review petition. The reasons which have been assigned by the applicant are not sufficient to condone the delay, because the only reason which in the application, it has been stated by the applicants that applicants are the owner of the property, and since they are residing in a village, therefore, they had no knowledge of period of limitation. For a system. The aforesaid reason cannot be said to be sufficient to condone the delay. It is true that a person who has who is not a law graduate may not be knowing the law pertaining to limitation, but they could have consulted their counsel specifically when the applicants were being represented by their counsel in appeal. Even otherwise, even otherwise, this court under the garb of review cannot reopen its order on merits. Under these circumstances, this court is of considered opinion that the applicants have failed to point out any sufficient cause for condemnation of delay of 5 years and 2 months. Accordingly, IA number 2132/2018 for condemnation of delay is hereby rejected. As a consequence thereof, the review petition is also dismissed as barred by time.
Right.
जी सर, करीब 1.5 साल डिले